Did you want to do Washington first?
That's good, Judge.
Okay. Yeah. All right.
Good morning, Your Honor.
Morning.
Your Honor, Tim Gibbs on behalf of Mr. Amos Washington. This is 21 CF 2413. Judge, this is a status hearing. We were seeing if we could get some kind of pre-plea investigation. I don't think we're going to be able to do that. We'll just need to leave him set on the trial docket for pretrial August 28th. Ms. Sandler and I will be starting to set depositions to get this case rolling.
Okay. Any objection to that?
No objection from the state.
All right. August 28th. Thank you, sir.
Thank you, Judge.
We have any private attorneys out there? No? All right. Who wants to go first?
I do have a few out of custody I can address,
Okay,
Judge.
good.
Judge, first out of custody, I'm going to have Mr. Ronald Collins. Judge, Mr. Collins is here on 22 CF 2265 and 22 CF 2266. This was a status hearing, Judge. Ms. Leon and I believe have stipulated that we can modify his contact provision to Matthew Brindle from no contact to no violent contact, and I'm happy to provide the court with an order for that.
That is correct, Your Honor. I'm not objecting at this time.
Okay. Fine. Thank you. No
Otherwise, Judge-
violent contact.
Thank you, Judge. Otherwise, we'll leave him set for the pretrial docket 828.
Okay.
So make another appointment between now and then.
Okay.
Yes, sir. Thank you.
Judge, otherwise, I do have Miss Jessica Duval. She is present, Judge.
Okay.
Your Honor, Tim Gibbs on behalf of Jessica Duval. This is 23 CF 37. Ms. Duval is present. We do have an agreement, Judge, if I may approach with a written plan of score sheet.
All right. All right, this is State of Florida versus Jessica Lynn Duval, 23 CF 37. You're Jessica Duval. Would you please raise your right hand to be sworn? You swear the testimony you give for is courts of truth, so help you God?
Yeah.
You want to enter a no contest plea to the charge of grand theft, less than $20,000, a third-degree felony, is that correct?
Yes,
Did you read and sign this plea and sentencing agreement form?
I did.
Are you aware of the rights you're waiving by entering this plea? Has anyone forced you or threatened you to enter this plea?
No.
Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No.
Are you happy with the work Mr. Gibbs has done for you on your case? Court finds the plea is freely and voluntarily entered. Court accepts it. Adjudicates you guilty, sentence you to 5 years probation with automatic early termination upon completion of all requirements. 30 days Okaloosa County Jail, credit for time served. Served on weekends beginning 8/4/23. $100 cost of prosecution, $415 court costs, $150 PD fee, restitution of $12,705 to Brendan Hazel, care of Rebecca Lynn Clark in Madison, Florida. And is there anything else?
I think that covers it.
Is that it?
Yes, Judge, thank you.
Okay, so she served her time on weekends?
Yes, Judge.
Okay,
Thank you.
all right.
So you'll get fingerprinted, then meet with probation.
And that, Your Honor, Charles Berry with state probation, that begins 8/4/23?
For the jail time.
And the
Yes.
jail
Okay.
wants the time that she needs to be there. So if it's going to be Friday at 5 to Sunday at 5 or
Yeah,
ever,
that's fine.
is that?
We had anticipated Friday at 5 until Monday morning
At-
at 7 or 8 a.m.
Well, make it Friday to Sunday, because she says she has to go to work Monday.
Very well. Thank you, Judge.
Friday at $1,700?
I'm not very
Or
good at all
or
that.
5 o'clock?
Friday at 5 o'clock
To Sunday
at 5,
at the same time.
American time.
And of course, we'd request cost of supervision be waived while she's
All
on
right.
probation. Judge, I do have some other matters that are out of custody that I'd like to address. I do see Mr. Powell has arrived if he wanted to go ahead and go.
Mr. Powell, come on up.
What is in custody, Your Honor?
They're not.
My client's in custody.
Well, come on up, let's see.
Thank you, Your Honor.
Dixie.
Thomas. Yeah, I just saw her first appearance. Good morning, Your Honor. Dixie Dan Powell on behalf of Rebecca Thomas. I'm covering for one of us. I don't know which one, Gil or Bo. I think Gil.
Is that from the firm of Powell, and Powell?
Yes.
Okay,
And Powell's,
Powell. Okay,
of counsel to Powell.
Yeah, apparently I have two firms, so I'm looking at both of them.
okay.
So that's the,
But not complaining.
she's a guardian.
I think I've got
That's her address.
this plea. Is that it? You need it?
And Your Honor, we were listed as counsel on this.
Yeah.
All right.
Pick it up.
I will.
Okay,
May we approach, Your Honor?
yeah. Is this going to be a plea?
Plea of sentencing agreement and a guidelines court sheet. This is on the violation of probation.
Are you Rebecca Jane Thomas?
Yes, Your Honor.
Would you please raise your right hand to be sworn? You swear the testimony you give for this court is the truth, so help you God?
Yes, sir.
You want to admit that you violated probation?
Yes, Your Honor.
Did you read and sign this plea and sentencing agreement form?
Yes, Your Honor.
Are you aware of the rights you're waiving by entering this admission?
Yes.
Has anyone forced you or threatened you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, Your Honor.
Are you happy with the work that Mr. Powell has given, in handling your case?
Yes, Your Honor.
The court finds the admission freely and voluntarily entered. The court accepts it. And, let's see. And this was 22 CF 1415, State versus Rebecca Thomas. Court's going to reinstate supervision, be placed on community control for the rest of probationary term, which terminates on 11/6/23. Waive cost of supervision, all monies to collections at her termination date. And adjudication is withheld. Okay?
you.
Stay out of trouble.
Sir.
All right. Anything further?
No, Your Honor.
Ms. Thomas and her husband been working for us quite some time, Your Honor. They do a good job.
Okay.
I have another quick matter, if I may. I don't believe it. It's not set for a hearing, but it's a motion for termination of probation on Rodney Barron, case number 2021 CF 1939. It's just, he's completed all his requirements and done over two-thirds of his probation, so I didn't know if we could do it today, or I need to, motion's been filed.
Well, who's the state attorney on it?
I can reset it to, or send an order in.
Yeah, Your Honor,
Let
I'm not aware.
Ms. Leon look at it, and then y'all, if you can stipulate to it, send me an order. If not, then if you want to have a hearing, we'll just get it set on a docket.
Okay. Thank you, Your Honor.
Okay, thank you.
You have a good rest of the week and weekend.
Anything else?
I have inmates and then
Me
some
too.
people.
If you have any people, anyone in the audience that's not represented by an attorney, want to,
Zachary Harrison,
Mr. Hen,
6 on the docket.
all right, we'll get y'all, here, come on up.
Your Honor, he's here on a violation of probation. The violation stems from a new misdemeanor charge that is still pending.
Ending?
The misdemeanor charge is still pending, so
Well,
you can ask him what he wants to do, but
what does the state say?
What's his name, Your Honor?
Zachary Henderson.
Oh, Henderson. The offer for the VOP is 12-1 incarceration, revoke and terminate supervision.
Revoking, that's her, oh, you want a public defender to represent you? You have to say out loud.
Yes, sir.
All right, I'll appoint public defender. We'll set you for about September 7th, miscellaneous.
That would be me, Judge, and September 7th is fine for me.
Okay,
That's fine, Your Honor.
Well, on my misdemeanor case, they told me that, they asked me if I wanted a public defender, and I told them yes, and they tried to say I didn't have one appointed to me, so I thought I had Jim Mullins, but
well, that's in front of Judge Ward, I guess, so I'm appointing you in the felony division. Mr. Williams here,
What's your name, sir?
Zachary Henderson.
he may be able to work out all the cases for you. I don't know, but,
No, sir, I wouldn't
You
interfere
don't?
with the
Okay.
misdemeanor, but I will say this, I don't know a Jim Mullins. He may be down in the south end.
I'm pretty sure that's what he said.
all right, September 7th, get with Mr. Williams and, see what you can do.
I need you to take this down to the clerk's office and fill it out, okay?
You gentlemen with
You
the
said, what was the state?
jacket and orange shirt,
I don't know anything about an offer.
that's it.
I've literally just this second got a point.
12-1. Yes.
And your name, please?
Joseph Jordan.
Joseph Jordan.
You have a private attorney, but it's number 1.
Who's your attorney, Mr. Jordan?
Matthew Boomershine, down in Central Florida. I didn't even see the need to contact him on this. The probation is agreeing to termination. I've satisfied all the terms. I guess it's up to the
Your Honor,
state.
I agree with state probation. I did see his motion, and I did check all our records at the office before I came over here, and he has complied and completed all the terms and conditions. If the court wants to terminate him, he doesn't have anything left to do.
I leave it up to the court, Your Honor.
All right, so how long you been on probation?
A while.
Um,
You have the exact date?
It's a 2019 case. I think he got 18 months probation on it. His scheduled termination date is 11/22/23, so.
Okay, I'll terminate
Couple
you.
months early.
Okay, you're terminated from probation.
Thank you, Your Honor.
All right.
Thank you, State.
Good.
You guys. Free to go?
Yes,
Thank you.
Just a possession charge.
stay out of trouble so you don't have this hassle anymore.
Your Honor, I do have another out of custody, Miss Lacey Alford. She's actually, I believe, on this afternoon's docket, but I believe we're ready to resolve it this morning if the
Okay.
court would like to hear.
Lacey? Okay.
Your Honor, Tim Gibbs on behalf of Miss Lacey Alford. This is 23 CF 1413. Got the written plea agreement right
And
here.
this doesn't require the score sheet.
Yes, it's a plea of misdemeanors, Judge, so it doesn't require a score sheet.
This is 23 CF 1413, State versus Lacey Alford. You're Miss Alford. You're Miss Alford.
Yes, sir.
Would you please raise your right hand and be sworn? You swear the testimony you give before this court's the truth, so help you God?
Yes, sir.
You want to enter a no contest plea to driving license suspended or revoked, a second-degree misdemeanor in possession of paraphernalia, first-degree misdemeanor, and the state's going to dismiss the felony, correct?
That is correct, Your Honor.
So you want to enter a no contest plea to those two misdemeanors?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevents you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Adjudicated guilty. On count 1, charges are dismissed. Count 2 and 3, you're sentenced to credit for time served, $50 cost of prosecution, $250 court cost, $100 PD fee, payable within 180 days before collections.
Thank you, Judge.
Yes, sir,
Okay.
thank you.
Good luck. Judge, I do have some other matters. I know we had Mr. Michael Bolaboy, who was set for this afternoon. Speaking with the state, we've already agreed to continue him. That's 21 CF 2621, 21 CF 2633.
Okay, what day did you want to continue it to, August 28th or something, or
We could do, it's a VOP evidentiary, Judge. We could do August 31st
August
or
31st?
September 7th.
September 7th,
September
evidentiary with
7th.
subpoenas.
Evidentiary with subpoenas, Judge, September 7th.
Okay.
And then, otherwise, Judge, I had a Mr. Michael Dillingham. He's 22 CF 2294. I believe he's still in the state hospital. That was a case where the court wanted another report from the department to determine if he still needs to be held involuntarily at the state hospital for competency restoration. I believe the department sent a new report either yesterday or Tuesday. I've reviewed that report and would admit it, move to admit it into evidence for the court's review if there's no objection from the state, and leave the court to determine, and based on the report, if he's still not competent to proceed and continue his involuntary commitment.
State stipulates to the report, Your
Send me
Honor.
an order then.
I'll send you an order, Judge.
Okay?
Otherwise, Judge, this morning I have inmates.
All right.
Isabel Green?
Uh,
For Dillingham, another status?
Why don't we do December 7th?
December 7th, Judge?
Yeah.
That works, thank you.
All right, sir, your name, please?
Denzel Green.
Mr. Green?
Number 5 on the docket?
Okay. Let's see. I think he's here on a, is it a pretrial or on a failure to appear case?
It's on a VOP, Your
No,
Honor.
hang on a second. What, is it?
Just-
I was just saying.
I'm sorry, I'm not the wrong person. Denzel Green, okay, yeah, this is a violation of probation, and, Mr. Green, let's see if, you don't have an attorney at this time, right?
No, sir.
Let's see what the state's offering you, maybe you want to take the deal or not. You don't
Yeah, I
have
take a
to.
deal. I take reinstatement.
Hang on a second, let's see what they say.
All right.
Your Honor, in exchange for an admission to the violation of probation, the state is offering to revoke and terminate a new term of supervision of 1 year drug offender probation, followed by 1 year probation with the same existing conditions reimposed. And of course, cost of prosecution, $100 for the VOP, and court costs, whatever they are.
So you want to do that, if you want to enter a admission, we'll revoke and terminate your probation and put you on a new 1 year drug offender probation where you got to get counseling and stuff, and then after that, 1 year of regular probation. You want to do that?
But when I get a bond today or something?
Unless you're being held on something else, you'll get out today, I believe.
Yeah, okay, I'll do that then. If I
Is
can get
that
out today, yeah.
correct? Is there any hold on him for anything else? Would he get out today? Mr. Berry or anyone?
We don't have any other holds on him. He was just here on the VOP for us, Your Honor.
You got any holds on you from another county or
Oh, no,
state?
sir.
Okay. So you want to admit that you violated probation? And I'll give you this, what they've offered.
Okay, that's fine.
Would you raise, okay, this is Denzel Green, case 22 CF 1403. Would you please raise your right hand to be sworn? You swear the testimony you give for this court's the truth, so help you God. You want to admit that you violated probation?
Yes, yeah,
Are you aware of the rights you're waiving by entering this admission? In other words, you're waiving your right to a trial before me, right to remain silent, right to an attorney, right, you're waiving all these rights. You understand that?
yes, sir.
Has anyone forced you or threatened you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Court finds admission freely and voluntarily entered. Court accepts it, will revoke and terminate your probation, sentence you to 1 year drug offender probation, followed by 1 year regular probation with the original conditions. What else was it? Standard court costs or?
Yes, Your Honor, cost of prosecution, $100, and if there is any other court costs associated.
$100 cost of prosecution, which you can pay off during the time of your probation. And any other costs would go to judgment, waive cost of supervision, and I guess you'll get out today. Yeah, adjudicated guilty.
Yes, Your Honor, may I approach with the score sheet?
All right.
Total score of 25.4 with 6 points for the violation.
That's pretty nice.
Number 7 on the docket. Also on our
Are you Ethan, is it Connect?
Yes, sir.
All right, he is here on a violation of probation, no attorney. Is there any, he's got something else here. It looks like all VOPs to me.
Yeah, in the morning, they're all VOPs, but he also has a new felony, new law. So,
Is that up
I
for
would-
today?
I'm not sure if I don't believe it's set for arraignment today, but
All right.
I filed it yesterday, the information.
It's at 8:31.
Judge, I don't know if you heard, it said 8:31 for arraignment on the new.
Oh, okay. Well, what's his new charge?
Judge, according to the clerk's office, it's 23 CF 1588. He's charged with fleeing elude as well as resisting without violence. That's set for arraignment August 31st.
Why don't we just set it for August, all this for August 31st?
Yes, Your Honor, that's what I was going to ask.
And then we can.
There's no way that I can, is there any offer today? And
Well, she doesn't have her file, and,
I'll take,
hang on one second. Why don't we set him,
can I please have some kind of offer?
well, we don't know, I mean, she doesn't know
Can I
yet.
have a recall?
Set him for August 10th.
Your Honor, the offer is, he scores 16 months in prison, and I was offering 12-1 with credit for time served.
For everything,
Yes, Your Honor. With,
including his new felony charge?
yes, Your Honor.
How much time you served in county jail?
Not very much.
Well,
According to the jail records, Judge, he's been in most recently since July 15th.
pick up 12-1, you probably end up doing, I don't know, 9 months, something like that.
9 to 10.
There's no way to get any kind of bond or anything like that?
I'll appoint public defender to represent you, and then they can see what they can do, okay? So we'll set you for August 31st. Maybe it'll be, everything can be wound up, and maybe they can get you some kind of deal where there's no jail or prison, I don't know. Okay?
I'll come out and see. Are we on for August 31st then, or August 10th?
August 31st.
All right, Judge. I'll come out to the jail and see you. Okay.
Okay, thank you.
Oh, sir. Let me go ahead and give you this, try to get this filled out and get it into the clerk, okay?
Okay.
Your Honor, Tim Gibbs on behalf of Ms. Kayla Burgess.
All
This
right.
is 23 CF 1138. Judge, I believe we have an agreement.
All right,
Leanne
this
is
is
reviewing that written plea right now.
23 CF 1138. You're Kayla Burgess.
Yes.
Would you please raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God?
Yes.
Okay.
And she still does need to sign that written plea, Judge. That was
Okay.
finalized this morning.
Score sheet and,
So, just as a reminder. That's what you want to do, I need you to sign. Right. I accidentally started signing there earlier. And today's date, please. All right, thank you. Your Honor, if I may approach. No objection to the score sheet. Apologies in advance for the atrocious.
All right. Ms. Burgess, did you want to enter a no contest plea, the charge of possession of a controlled substance, a third-degree felony, and possession of paraphernalia, a first-degree misdemeanor? Is that correct? Did you read and sign this plea and sentencing agreement form?
Yes.
You aware of the rights you're waiving by entering this plea? Anyone force you or threaten you to enter this plea?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
I
Well,
think I may
fine.
have neglected to put count 2 on there, Judge, for the paraphernalia charge. It should be time served.
Okay.
No objection to the court amending that.
All right, the court finds the plea is freely and voluntarily entered. Court accepts it. You are sentenced on count 1, 2 years probation, $100 cost of prosecution, $515 court costs, $150 PD fee. Have a substance abuse evaluation with any recommended treatment, random UAs, and count 2, you're sentenced to time served. And you're also adjudicated guilty on count 1.
Thank you, Judge.
Okay?
And for the record, she does have a hold for Santa Rosa County for a violation of probation there. We were trying to see if we could get that resolved. We were unsuccessful, and we hadn't heard back from the prosecutor there, so she will have to go to Santa Rosa before she's released.
Okay,
Thank you, Judge.
thank you.
Your Honor, we request supervision, please be waived.
Okay,
Thank you, Mr. Berry.
Jamie Calhoun, the Burgess is seated at the table.
Your Honor, Tim Gibbs on behalf of Ms. Jamie Calhoun. This is 22 CF 1300. Judge, Ms. Calhoun is first here for a status hearing on her competency. I believe the Florida State Hospital had filed a report recommending that she be found incompetent. I've reviewed that. I have no objection to that report, certainly no objection to it being admitted, and the court finding that indeed she is competent to proceed.
yes, Your Honor.
court so finds she's incompetent to proceed. Do we need a status confident?
She is competent, Judge. She is restored to
Yeah.
competency.
Oh, is competent?
Yes, Judge.
Oh, I thought you
Yes,
said
yes.
incompetent. Okay.
Sorry, I
All
talk
right.
fast sometimes.
Court finds she's competent. What do we need to set her for?
Well, Judge, we have an agreement to resolve the case today if I can approach.
Good.
The score sheet, you have it? Oh, okay, thank you.
The recording plea does reflect that it is a downward departure, Judge. However, after reviewing the score sheet, it is not a downward departure, it is a guideline sentence.
All right, you're Jamie Joe Calhoun,
Calhoun, yes, sir, Your Honor.
and it's 22 CF 1300. Would you please raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God?
Yes, Your Honor.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, Your Honor.
Has anyone forced you or threatened you to enter this plea?
No.
And you're entering a plea to count 1, burglary of an occupied dwelling, a second-degree felony, and count 2, felony petty theft, a third-degree felony. You understand that?
Yes, Your Honor.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes.
Court finds the plea is freely and voluntarily entered. Court accepts it. You're sentenced to 14 months Department of Corrections, credit for time served concurrent. 14 months on each case, concurrent. Credit for time served concurrent. $100 cost of prosecution, standard court cost, $150 PD fee, due within 180 days of release before being sent to collections. You have 438 days credit as of 7/27/23, which is 14 months, 12 days. Therefore, you're eligible for release. And this is not a downward departure, correct?
Correct. It ended up being a guideline sentence, Judge.
Okay, so she would still have to probably be transported to the reception center?
I do have an order, Judge, for you to sign that would release her. The jail generally is satisfied by an order from your bench.
Any objection to that? She's adjudicated guilty on both counts. Any objection to that?
And where do you have information on the credit that she has?
Based on the fact from the jail website that she's been in since May 15th of 2020.
Okay,
If you're satisfied.
yes.
Okay. If I may, Judge. And I believe otherwise the minute sheet can reflect that she is eligible for release.
Well, I mean, I'll sign this, but my understanding was if she's sentenced to Department of Corrections has to release her. Like she'd be transported down there and,
We can work to confirm that with the jail as well later today.
yeah, confirm that, and if it's okay, have a stipulated order sent to me,
I can send that to you, Judge.
state and you.
Certainly.
Because I don't want some weird thing to happen, that she's sentenced to Department of Corrections, she doesn't show up, and they say she's escaped
Right.
or something.
Right.
And they're going to just send you down there, immediately release you, give you probably a bus ticket right back. So, the reception center is where they send people when they receive you, and they give you a medical checkup, and then they figure out how much time you're supposed to be. They're going to go, well, you've already served your time. Here's a bus ticket back home. So I think that's but I have no problem releasing you from the jail. I just want to make sure that it's
Sure.
correctly done, okay?
Bridgeway, yeah, also.
We'll try to get you released either later today or early tomorrow if possible.
Well, see, Bridgeway is supposed to come pick me up today, and they got me a bus ticket to Gainesville.
Mr. Barnes, her family lives in Gainesville, Judge. Mr. Barnes has been in touch with my office and is working on getting her a
The
bus ticket
reception
down there.
center down at the prison is
Believe-
like 20 miles from
I think it's in
Gainesville.
Ocala.
I've been there many times, not as a prisoner, but I used to be a prosecutor down there, so I know.
What we'll do is, we'll work to confirm that she's eligible for release.
Yeah. They don't want you in jail or prison, and I don't want you to spend 1 minute there that you don't have to, okay? We just want to make sure it's done right.
He doesn't want to make sure that if you get released, that something crazy happens and
Yeah,
you get a
but they
warrant
got-
out, you
I
get a
got
warrant
it.
out for you.
Okay, it's just
Yeah.
that Bridgeway has me a room set up for tonight and have it arranged for me to go in the bus
I'm going to
in
talk to the
morning.
jail as soon as I can this morning. We'll try to get that confirmed, okay?
Yeah.
We'll try to get you released today if we can.
Okay.
Thank you.
Thank you.
Thanks, Ms. Calhoun. Your Honor, Tim Gibbs on behalf of Jesse Gainey. This is 22 CF 401, 22 CF 402, and 20 CF 2929. Judge, I had been speaking with the state about trying to see if we have resolution today. Ms. Leone has recently gotten this case from a different prosecutor, from Ms. Barrickman. She needs some time to be able to review the case in order to try to make an offer, and we can start negotiations. So I'd like to continue this to August 10th. Is that too soon?
No, it's not too soon for a status.
August 10th for a status hearing, and we may have a bond hearing that day as
Hopefully we
well.
can get your case resolved, Mr. Gainey, August 10th. Thank you.
We'll probably set up one here. I'll come talk to you about it.
All right.
Yeah. Thank you very much.
Right,
Your Honor, we've reached an agreement in this matter, if I may approach.
okay. You're Jim Semino.
Yes, sir.
This is case 22 CF 1356. Would you please raise your right hand to be sworn? You swear the testimony you give for us court's the truth, so help you God?
Do.
Okay. You want to enter it, you want to admit that you violated probation?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Anyone force you or threaten you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir, I'm not.
Are you happy with the work Ms. Rivers has done for you on your case?
Absolutely.
Is it an adjudication?
Yes, Your Honor.
Court finds the admission is freely and voluntarily entered. Court accepts it, adjudicates you guilty, revoke and terminate probation, sentence you to credit for time served, $150 PD fee, $100 cost of prosecution.
Yes, sir.
Okay?
Thank you, sir.
Thank you.
And Your Honor, those monies and any other monies to collections?
Yeah.
Thank you.
Vanessa Tejo, okay?
Your Honor, we're here on her request for a Nelson hearing.
All right, tell me, Ms. Tejo, what's your problem with Ms. Rivers? Why do you feel that she's ineffective?
I was just wanting a change of counsel. Ms. Rivers and I've testified in court during a trial where she was the defense attorney and I was for the state. We've sat in 2 depositions where I was for a state witness and she was a defense attorney. And then she was the one standing at the podium when the first charges were filed against me when she was working for the state.
So Ms. Rivers, is that correct?
Yes, Your Honor. Now, I did not file any charges on her when I worked at the state attorney's office. I had a different part of the
I think that's sort of a
alphabet.
conflict of interest. You're not ineffective, but I think that's a conflict of interest, so I'm going to appoint the Regional Conflict Counsel to represent you.
Thank you, sir.
You got a good point. You need to feel confident that there may, typically, you got to have a good reason for me to let, anyway, she's not ineffective, but I think you do have a good point. There may be a potential, I can understand you having a concern, so I'll appoint Regional Conflict Counsel to represent you.
Thank you, sir. Appreciate it.
And that will be, when's she set for?
I think my next court date's August 28th.
28th, okay. And we'll see what happens.
Thank you, sir.
Okay, thank you.
Vernon Webb. Your Honor, this is Vernon Webb. He's before the court on 22 CF 2054. There's one other issue that the state and I need to clear up. Ms. Gleason just took over as the prosecutor on the case, so we're just asking to set this for the 1:30 docket, and we'll
This
have it resolved by
afternoon?
then.
This after, you talking about this afternoon?
Yes, sir. this
Okay.
afternoon. Okay. She wants to set it for the 10th. You still won't have done all your time by then, so that'll be
Okay.
fine.
It's fine.
Okay. Your
Okay.
Honor, she's asking for August 10th, and that will be fine with us, and it
Okay.
is fine with my client.
All right, Mr. Webb, see you August 10th. Hopefully we can get it cleared up.
Yes, sir, thank you.
Thank you.
Same results, right?
Yep.
Yeah.
Your Honor, the next on the docket, I have it as number 19. On my docket is Jody Yawn. He is case number 21 CF 829. Your Honor, we've had him on the docket the past couple of times because he is currently at the Florida State Hospital. There was supposed to be a review done, and a review had not been done. Florida State Hospital has now finally done a review, and they are sending him back. You signed an order to have him transported. He's just not here yet. So I would ask to put him on the 8/28 docket. That will give him a chance to get here and for me to meet him.
No objection.
All right, August 28th, thank you.
Charles Russell, Public Defender's Office. Judge, this is McKelton Lett. Case number is 21 CF 1977.
Okay.
Mr. Lett is before the court. The court scheduled this court date. We were scheduled for trial last cycle. We thought we had a plea agreement worked out. During the colloquy, Mr. Lett indicated that he did not understand the plea agreement, so the court postponed the case to today. I have met with Mr. Lett. Last meeting, he does not want the plea offer, is my understanding. So I guess we just need to put this on the regular pretrial conference.
So what was the plea offer?
Judge, state's offer would be to plea to counts 2, 3, and 5 in exchange for the 1, 4, and 7. That would be 6 years in the Department of Corrections, followed by 8 years of sex offender probation. That offer will be at the next pretrial conference.
So you still want to reject that, or you want to accept it?
Jake,
Okay.
may I talk to you, sir?
No, you got an attorney, you have to talk to me through your attorney.
Every time I try to, he ain't trying to do what I asked him to do. Every time I try to tell him I had got a form, I was trying to get my medical records. He said he's not a doctor, and they want me to bring the authorization form to release my medical records, and he telling me he not a doctor. Like, it's so much. He came and talked to me. He telling me he ain't a doctor. Like,
Russell, I mean, what do you?
What Mr. Lett is referring to, Judge, I don't know if the court recalls, but at the last court hearing, he indicated that the jail was not giving him his medications. I indicated to him before, including the last time that we met, I am not a doctor. Even if I was his doctor and prescribed him medications, it is up to the jail to have him evaluated by their doctor, and their doctor decides whether or not to give him medication.
Yeah, Mr. Russell doesn't have any control over that. That's all the jail.
Yeah, but I mean, how can I get my medical records? Because the HIPAA's Act. How can I get my medical records? The lady won't.
You'll have to talk to the jail. See, they got your medical record. He doesn't have control over your medical stuff. He's
supposed to be able to tell them about my situation.
No, you got to tell him about your medical situation. He's not representing you in regards to the jail. He's representing you in regards to the state. The jail and your medical is between you and the jail staff. You got to talk to the nurse at the jail or the doctor at the jail and tell them what you need. He can't make them.
The jail, they thinking I'm just talking, and I'm for real. Like I'm not even from here, sir. And I take medication.
I know. Well, Mr. Russell can't make the jail give you medication. You're going to have to ask the jail doctor or nurse to give you your medication. And he doesn't have control over the jail to give medication. So I don't know what the situation is, but talk to the doctor or the nurse at the jail about getting your medication. Because he can't make them give you. He's not a doctor. That's what he's trying to tell you. He can't just prescribe medication. He can't make them give you anything. He can't.
I just want him to get my medical records. That's what I'm saying.
Well, it has nothing to do with this case, does it, Mr. Russell?
No, sir.
He doesn't have authority to get your medical records when it's not. You'll have to hire a private attorney to do that kind of stuff if that's what you want to do. He doesn't have authority to do what you're asking him to do. He can't do it. It's between you and the jail, not Mr. Russell representing you on a criminal offense. What you're trying to do is not a.
He keep telling me he keep telling me to take this deal, take this deal, which I'm not finna take this deal.
All right, we'll go to trial and see what happens. Maybe you'll be found not guilty. Okay, we'll set it for August 28th. Thank you. Hopefully things will work out for you.
Charles Russell, Public Defender's Office. Judge, this is Mr. Weiser. Case numbers are 21 CF 1739 and 21 CF 1740. I had set a motion for release of evidence in this case for hearing today. The problem is that Mr. Weiser has recently this week filed a motion for Nelson/Ferretta what I would propose to do is continue my motion for now, and I'll reset it when I can, but set his motion for Nelson/Ferretti hearing for August the 10th. And we can set it morning or afternoon, it's up to the court.
No objection.
All right, August 10th, and it sounds like you filed a motion for what now?
You filed a motion for Nelson's.
No, you filed a motion for what?
Oh, I filed a motion for release of evidence.
Okay. I mean, you're working his case, right? You're getting your discovery and doing all that? Okay.
Correct, Judge. Mr. Weiser has filed several motions for Nelson and Ferretti.
All right.
Did you want to do it at 9, Judge, or 2?
2, August what, 10th, you said?
Yes, sir.
Thank you, sir.
All right.
Thank you, Judge.
Yes. Your Honor, Tim Gibbons on behalf of Antonio Betancourt. I'm also covering from Mike Gates, who has Mr. Betancourt on docket this morning for 23 CF 826. I have Mr. Betancourt on 23 CF 1116. Judge, this was set for a status hearing for Mr. Betancourt. We had filed a motion, and Judge, court signed an order for him to be evaluated for competency. We're still waiting on that order. We'd like to set him for August 31st for a status hearing for competency.
Your Honor, I would ask that the cases be set for August 28th pre-trial. It's only 3 days before, and this
Okay.
should,
August 28th.
Understood. Thank you, Judge.
All right, thank you.
I'll inform Mr. Gates.
Okay.
Thank you, Judge.
Next, I have Chrissy Holly with Mr. Williams.
Morning, Judge. This is Christy Holly. Ms. Holly has 2 cases before the court today. She's got a violation of probation this morning, an arraignment on a new law violation this afternoon. What I'd like to do is go ahead and enter a denial as to the violation of probation, and if the court's amenable to it, go ahead and arraign her on this afternoon's case so they can take her on back.
I don't have the information of what, let me see, maybe I do.
Oh, yeah. Case.
And an information has been filed, Judge.
Christy Holly.
Correct, Judge.
All right, Ms. Holly, you are, your attorney has entered denial on the violation of probation, but you got some new charges, smuggling contraband into prison. This is that would be case number 23 CF 1405. There's 2 counts of that. And that looks like, is that second-degree felony, third-degree felonies on those?
Judge,
on the
she's...
new law is a second-degree felony.
Second degree, okay.
Yes, sir. Counts 1 and 2 are second degree. Count 3 is a first degree misdemeanor.
Yeah, and fraud, giving a false ID to law enforcement officers, so those, that's what you're charged with on your new. Would you like me to appoint the public defender to represent you on those matters?
Well, Your Honor, I was wondering if there was any way, like, that I could possibly get, like, community control or reinstated, like, combine them. I've never been on community control, but I think the structure would help me. I need, a little assistance. I have a place to live that's
Why don't we
steady
put you on August 10th and see if they can get it resolved? Sounds like she wants to enter a plea.
Well, Your Honor, I'm handling the new case,
Yeah.
and Ms. Berrickman is handling the VOP. And I understand that for the VOP, she scores prison, so
Oh,
we
she
need some
does?
time to,
Well, yeah, that's that's what I'm saying, August 10th, or, is that enough time?
August 10 is fine, Your Honor.
Okay, maybe they can offer you something you want. If not,
All right.
August 28th, pretrial, we'll see what happens.
Okay, thank you.
Okay. I'll appoint the public defender to represent you on the new cases. Okay.
Thank you, Judge.
I take this?
Yes, ma'am.
Okay.
Sure.
Thank you.
Alicia Hutto.
Good morning, Judge. This is Ms. Hutto. I think I've got her on here. I'm sorry?
Number 22.
Being set for a bond hearing, Judge.
Mr. Williams, may I speak with you for 1 second right prior to you making your argument?
How many more inmates we got back there? 2, that's it? Want to bring her back this afternoon so you can talk to her about whatever this is you're talking to her about?
Judge, that's fine.
Okay.
I don't need to come back with the 130.
All right, this is Savannah Matthews.
Judge, Ms. Matthews is here on a motion for bond. She also has a new law violation set, I believe, for this afternoon. Yes. And so I'd like to go ahead and arraign her on that as well.
Okay, on the new charge, 2023 CF 1408, you're charged with possession of a controlled substance without a prescription, third-degree felony, resisting an officer without violence, that's a first-degree misdemeanor, and possession of narcotic equipment, a first-degree misdemeanor. You want me to appoint a public defender to represent you on those cases?
Yes, sir, please.
Plead not guilty?
That's correct, Judge. 15 days pre-arraignment motions and demand for jury trial.
Okay. So those are new, okay, now you want a bond hearing on these?
That's correct, Judge. On the violation of probation, if the court wants to swear, I'll go ahead and elicit testimony.
What's her bond on the new charge? Are you making a bond motion on just the VOP?
Judge, I'll go ahead, and if the state's prepared, the original motion was done on the VOP, because that's the one where she doesn't have a bond. She does have a roughly $5,000 bond on the new violation, and $5,000 is what we were requesting on the violation of probation. If the state's willing to proceed on both of them, I'll ask for $5,000 on both.
We can proceed, Your Honor.
All right, Ms. Matthews, would you please raise your right hand to be sworn? You swear the testimony you give for is course the truth, so help you God?
Yes, sir.
Okay.
All right. Your Honor, I'll ask the court take judicial notice of the file. She's been incarcerated since April 19th of 2022 on the initial bond or the initial VOP on the other case. The
Well,
arrest date is June 24th of '23, so she apparently got out at some point.
Well, she was not out on,
I think
I mean,
what
she was
happened
not
is
in
staff
jail.
pulled the original arrest date on the original charge. So that should read, I'll orally move to amend that to June 24th of 2023.
That's when she's been in custody.
This time, that's correct, Judge. Ms. Matthews, can you make, currently your bond on the violation of probation is none. Can you pay a bond of $5,000?
Yes, sir.
What's your work situation?
As of right now, I'm unemployed.
I notice you've got an arm in a sling.
Yes, sir.
How did that happen?
The officers broke it during my arrest, resisting without violence.
Can you talk into that microphone?
The officers broke my arm with resisting without violence at the scene.
All right, and do you go to school? What do you do during the day when you're not in jail?
I take care of my mother, who is disabled. I have full power of attorney over her, who is also right now doing chemo and radiation treatments. And I have full, like I said, Your Honor, I have full power of attorney. So she's not even been able to see the doctor within 30 days.
And what's the situation with your father? Do you look after him as well?
Yes, sir. He is also going treatment as well. He is going through chemo and dialysis.
Have you been going to school?
I have been enrolled, yes, sir.
All right, where are you enrolled?
I'm going for my GED at the high school here.
Okay. And would you be able to, where do you live?
3001 Jim Green Road, Crestview, Florida.
All right, that's here in Crestview.
Yes, sir.
And how long have you lived in this area?
My entire life.
Other than your father and your mother, do you have any other family in the area?
My entire family.
And have you lived in this area your entire life?
Yes, sir.
Judge, we're simply asking that she be given a bond. So that she can continue in school, continue looking after her parents, and go ahead and receive medical attention on the outside.
May I cross-examine, Your Honor?
Yes.
Ms. Matthews, you were on probation on or about April 18th of 2023, correct?
Yes, ma'am.
I'm sorry?
Yes, ma'am.
And you were supposed to report to probation during that time?
Yes, ma'am.
And you didn't report, right?
I was unable to, yes, ma'am.
You were unable to? Why?
I had no transportation, I was unable.
Okay.
All right, and I was,
All right. So you were unable to be located during the month of April, May, and June, correct?
don't know why, but yes, ma'am, I guess so.
Okay. Are you aware that Mr. Berry with probation, while you were on community control, went to your mother's house where you are listed to have been living, and your mother told Mr. Berry on April 20th that she had not seen you and she had no means to locate you?
My mother is not in her right mind. She is unable to say or vouch even for herself.
Okay. Are you also aware that your ex-boyfriend, Kelly Hutto, also notified Mr. Berry of the same information?
It's my ex-boyfriend, ma'am.
How long has your mother been, the bond motion says your mother had a knee replacement and you must take care of her medical needs. How long ago did she have a knee replacement?
She had a knee replacement, it was right maybe about a year ago. This is her third replacement, but she had a metal rod put down her leg as well. And she is also undergoing treatment for cancer on her lungs right now.
And you've been taking care of her. Is it your testimony today that you were taking care of her on April 20th when Mr. Berry reported to your mother's house to look for you, and April 21st
Yes,
of 2023?
Yes, ma'am.
You were at the house?
Yes, ma'am. I was there at the residence.
I'm sorry, I couldn't hear you.
Yes, ma'am, I was there at the residence.
You were at the residence, okay. And did you ever report to probation at all? Did you call Mr. Berry during the months of April, May, and June? You did not. And then you were picked up by law enforcement, arrested on June 24th of 2023 for the new charges of possession of a controlled substance, paraphernalia, and resisting without violence, correct? And your arm, you said, was broken, is that correct?
Yes, ma'am.
Did that happen when you were fleeing on foot, running away from law enforcement after bailing out of a vehicle? You were running from the law enforcement?
I was very compliant with the law officers, and I put my hands behind my back. They jammed my arm up, and just like the doctor, whenever I was set out to the orthopedic surgeon, said that they're also worried about the nerve damage in my hand, and it could be pinched by the bone that's broken in my elbow back here.
Okay. And you're also here for violation of probation for a positive urine analysis, changing residence without permission, correct?
I never changed my residence, ma'am.
Okay. I don't have any other questions, but I do have a witness, Your Honor. And
Ma'am, is one of the reasons why you have a power of attorney for your mother, is that based on any sort of mental or?
Yes, she is mentally ill. I got her whole entire record. Even the Mr. Berry and them even have where I have full power of attorney over her, and why, the whole medical chart on why. She's got Alzheimer's. She's, like I said, Your Honor, undergoing with cancer. She's got spots on her lungs. And my father is also doing dialysis, Your Honor.
Nothing further, Judge.
say would call Mr. Berry from probation.
Mr. Berry, come on.
Your Honor.
Would you raise your right hand to be sworn? You swear the testimony you give for this court is true, so help you God?
Yes, sir.
Okay.
Please state your name, sir.
Charles Berry, Jr.,
How are you, or what's your title?
probation officer.
And how are you involved in the case against State of Florida versus Savannah Matthews?
I was not, she was not assigned to me, she was assigned to Ms. Galogly, but I was doing the home verifications, me and Ms. Galogly were. I wish her mother was on supervision because I can find her mother. I can't find her at that house, but I can find her mother there.
Do you recall how many attempts that you made to contact or make contact with Miss Matthews at her mother's house where she is listed to be living?
Minimum of 5 or more, and she's on community control, so she's supposed to be there.
And during the months of April, May, or June, was Miss Matthews, while on community control, ever able to be located?
No.
When her mother, when you spoke to Miss Matthews' mother, was she walking to the door? Did she answered the door?
Yes.
Did she seem to have any disabilities that needed 24-hour care?
No.
Did you ever meet her father?
I've met him previously, but he does not live in the same residence as them. I know him from previous supervision.
Is there anything else that you would like the judge to know before making a ruling on a bond?
Your Honor, we worked, Ms. Galogly and Ms. Flowers worked diligently to try to help her. How she's not dead, I have no idea. Because she uses drugs to a crazy degree. We tried to get her help. We actually had a deal, if you will, worked out that she was going to do 30 days and terminate this supervision.
And that was the prior violation
The
of probation?
prior violation. We were going to be done with this. She agreed to do it. And then she stood right there at that podium on the day it was to be done after Ms. Flowers and Ms. Galogly and the state had agreed to something and she wouldn't take it. And she came in, we talked to her, and then she absconded on us. Couldn't find her.
Okay, Mr. Williams.
All right. With regard to the question of the mother's disability, you testified that she did not appear to have any disability. Do you yourself have any medical training or experience?
Absolutely not.
You've never worked as an EMT, paramedic even, nurse's aide, anything?
No.
Okay. Now, is it correct that you have or have at least been shown documents where she has a power of attorney with regard to her mother?
I personally have not. She may have shown that to Ms. Galogly, but I haven't seen it.
All right, so you don't know whether it's just a power of attorney or guardianship or what the nature of the document is? That is correct. And that she, quote, uses drugs to a crazy degree. That's your opinion based on your interactions with her and based on the charges that she's had. Is that correct?
Yeah, my interactions with her.
I mean, you've not quantified in any way what drugs or how often, anything like that.
If she wanted to tell the truth under oath right now, she would tell you she does.
All right, that's all the questions I have for Mr. Berry.
No other
All right.
questions?
I'm just going to leave the bonds where they are right now. Thank you.
I have a bond.
Court date is, next court date, what is it, 28th of August?
That's correct.
Yes,
That's
Your
what I have, Judge.
Okay.
Your Honor. Your Honor, may I speak up, please? May I ask that I be put on GPS or anything that, and you reconsider, please, sir? I have an arm that has got a pinched nerve in it. I need to get out to orthopedic surgeon. Your doctor there at the jail and the orthopedic surgeon I was sent out to is very concerned about the nerve damage, as well as I'm very concerned with my mother. Cancer, Your Honor, does not wait for anyone. I have been sober. I have been in your jail for 30 days. I'm willing to wear a GPS monitor, house arrest monitor, anything that you would consider, Your Honor, please. I'm at your mercy with this from my parents.
Thank you.
Denied it.
He's denied it, yes, ma'am. Morning, Judge. This is Antarius McLean. He's got 3 cases before the court. I spoke with him last Friday, I believe it was. He was given an opportunity to review all the evidence on Thursday with my investigator. During the course of the conversation last Friday, Mr. McLean just indicated he wanted to proceed to the Nelson inquiry, so that's what we're here for today.
All right, Mr. McLean, tell me why you feel Mr. Williams is ineffective for you.
Thank you, sir. I was told he had told me, like, don't worry about the 34 months that was on the table because he was going to put in for a suppression hearing. Every time I ask him questions about my case, he always tell me it's not up to him, it's up to the jurors. He gets aggravated when I ask him simple questions that pertain to my case. Say slick remarks like, I ain't put you in here. And you better try to find God if I don't already know him. I'm lost from understanding nothing because he don't break down nothing to me. I'm lost. I don't really know. He don't break down everything. Everything he say he gonna do or put in, it don't happen. He don't put it in. It's always excuses. I also asked him about the habitual felon, the felon that the state was seeking, and he say, well, he don't know nothing about it. He say, and it's possible. He don't really know. I asked him, have he went over my case? He said only the things that I asked him to look at. Other than that, he went over the notes that Mr. Charles Russell, my last attorney, had left for him in there. I'm confused. I thought maybe he was gonna help me, work for me, or not just work for me, just tell me what should I do, what not to do. I'm confused. I feel like just been forced on me. Like I got
Okay, let me ask him some question. How long you been representing him, Mr. Williams?
Judge, I am in one case the 4th attorney. I am in the others the 3rd attorney, and I've been on the case. I started back at the public defender's office again in October. He had a court date after that where he had a Nelson hearing set regarding Mr. Russell. Mr. Russell and I did talk about the case. I actually reviewed the files then and made work product file notes in the file. And when he came in for the Nelson inquiry, he decided to go ahead and stick with me. By that point, I think I'd met with him the first time. So I've been on the case, I'm going to say, since November or December.
Have you provided him all the discovery that you've received from the state?
I have, Judge. And then my investigator sat down with him, let him listen to the depots that hadn't been transcribed, and let him look at the videos.
How many times have you or your investigator met with Mr. McLean?
I've met with Mr. McLean at least twice, maybe 3 times on the case. When I went out to see him originally, I didn't.
Not your investigator.
My investigator has met with him at least once that I sent him out. He may have gone out other times for other attorneys.
Have you had a chance to explain to him what habitual felony offender means?
I have, and as the court's well aware, I tend to over-explain things, and because the court's heard me do that in the courtroom before. So I explained to him what I think he's talking about is when I initially looked at the files, there was actually, Mr. Russell had made a note that HFO had been filed. I didn't find a copy of the notice in the file, and I explained that to Mr. McLean. But I went ahead and explained to him what HFO meant, that it would double the statutory maximum. It would essentially take him out of the sentencing guidelines. The other cases, no HFO notice has been filed. I did find where the state had filed an HFO notice, and when I met with him the time before Friday, I explained to him that I had found that.
Did you convey to him any plea offers that have been offered by the state?
Yes, I have. In fact, we had a conversation one night where he said, basically just get anything off of it. And I looked at it and I told him there was a count involving vehicle theft from a bail or from a lessee of the vehicle that was, he had a romantic relationship with. And she didn't want to proceed forward. And I explained to him that even if we got that off, the number of points associated with that charge was not going to diminish it very much, and went over how many points it would take off. I talked with the state attorney. They agreed to dismiss that count. At one point, they'd even agreed not to seek the HFO sanction. And brought him an offer for 34 months.
You got the state to agree to come off the habitual felony offender, and you got the state to dismiss one of those and
to agree to dismiss it in exchange for a plea to the others. It still remains, and the HFO still remains because he's not accepted the offer.
Well, and you've conveyed to him that if the state made an offer and he accepts it, I go with that. I don't, but if a jury comes back with all things are open, it could be double time or whatever if the HFO's filed and all that. You've explained that to him?
Judge, indirectly, we had a conversation last Friday where he asked me about a cap. And he'd asked me about a cap before. And I explained to him that if it's a cap, it's not going to be at 34 months. And his response was, well, Mr. Williams, if I score 34 months, how could they make a cap higher than 34 months? So I realized he really wasn't understanding the difference between statutory max and the guidelines, and so I deep dove into that with him and went over the statutory max that he was facing and that the court could sentence him to anything up to that. I didn't think it was likely that the court would max him out, but the court could do so.
All right. Well, Mr. McLean, it sounds like Mr. Williams is doing everything he can for you. I'm going to let him stick with you a little bit longer and see how it goes. It sounds like he's got some pretty good possibilities for you. If you don't have him, you're going to be either on your own, hire an attorney, and they typically don't have investigators to just go. State attorney, the public defenders has investigators, and it sounds like he's making efforts to try to get the best possible situation for you. And so at this time, I'm finding he's not ineffective in denying your Nelson motion.
Thank you, Judge.
Okay. Thank you.
Okay, Mr. McLean.
Get with him, Mr. Williams.
Matthews,
Mr. Williams,
yeah.
get with Mr. McLean as soon as you can and go over any updated pleas or
I will,
offers or
Judge.
motions. Thank you. Calhoun?
I'd like to recall Ms. Calhoun, 22 CF 1300. She was the lady that we had just pled to 14 months DOC. I did reach out to the jail, to Lieutenant Cantler, who's a lieutenant over ACR at the jail. I have emails that I could show the court. I did copy your judicial assistant to them as well. According to Lieutenant Cantler, if the court does sign an order, she is eligible for release and DOC would not have to clear her.
I have reviewed that email.
Okay, well, give me the order then.
Thank you, Judge. Thank you. And I did also send a separate order to find her competent to proceed.
Okay, thank you.
Thank you so much. God bless you.
I believe that's all I have for this morning.
Ms. Rivers, you have anybody else?
No, Your Honor.
Mr. Williams? No, okay.
I don't have anything further, Judge.
Anybody?
I don't have anything, Your Honor, for
Just
this
have
morning.
afternoon at what, 1:30?
1:30?
1:30.
Yes, sir, and we've done two of mine, probably some others, in terms of getting this afternoon cleared down. So it should go very quickly.
Okay, see
No, I'm sorry, Your Honor.
you at 1:30.
Yes, thank you.
1:30, Judge.